Well, it's a pleasure to be here with you. I want to talk a little bit about the process because I think back in 2014, there might have been a builder committee that Ben Wrigley and I were working on. And so I think we did the redraft together in 2014 with the builder committee. And then Priscilla assembled a couple of your colleagues again for another builder committee to take a look at the contract, and then invited me in kind of toward maybe the end of those meetings just to get their feedback on what they wanted in the contract. And then we took that and made some changes and some polishing, I would say, because frankly, a lot of the substance is still there. There isn't a huge amount of change. One of the goals was to try, imagine this, to eliminate the legalese, get a little bit more plain language in where we could to potentially reduce the length. And there was some archaic terms, I can't remember if telegram was still in there or something else. So just kind of pulling out things that folks aren't doing or that don't make sense anymore. But I echo what Priscilla said. I mean, this is your business, and this contract is meant for you to use, and it's meant to address circumstances that give you headaches. And maybe we can close the loop on some of those headaches by changing contract language. But how many people use the HBA contract? Okay, that's really great because it has been an intentional process to try to get some gems in there. At least I would call them gems. And if you're familiar with the HBA contract, the way it's set up is you have your contract and then there's a bunch of attachments. But what I have seen over the years is builders develop custom attachments that work for their business, especially around plans and specifications, and developing their own maybe proprietary way of communicating their specifications. So this is meant, this contract package is meant to be very helpful and useful, but you can also modify if the specification sheets don't work for you and you've got a better way of working through what you need with your customer, then work what works for your business. If you can imagine a new builder coming onto the scene, these documents will be a great foundation for somebody who's really new. And I can tell, I mean, there's a lot of experienced builders in here. You can use your own experience to develop them in a way that is good for your own business. So, let's see here. I'll just put my glasses on. Let's see. Bear with me.
Yay or nay?
Hang on a sec. Let's see. All right, there we go. Got it. Okay, so as Priscilla mentioned, this is an update from the 2014 draft, and if I could just give you the big picture look at this. We reduced it in length, but not much, only a half page. So I'd like to say we did a good job in 2014 of trying to reduce the length of it. This contract as a whole is about 8 pages, which in the scheme of contracts might sound long, but it's not. And frankly, if you wanted to reduce the size of the font, reduce the spacing, you could probably get it down to 7 pages. But we wanted to look customer friendly. One of the things that I think is a real advantage is to have the HBA brand on it. I think that HBA branding and the fact that you're a member of a reputable association is really important. So overall, reducing length, getting rid of some outdated language, and simplifying the language. One of the a lot of these are minor changes, but they're because of problems that I have seen builders running into. One of them is calling out that you are not an architect or licensed design professional, because you all know you can design up to a certain square foot threshold. If you get over that, you need to be licensed. And we have had a few builders who get crosswise with their clients, and the client says, I thought you represented that you were a design professional. And if that's a situation, it can get pretty ugly pretty fast, because some of you might sketch in front of your owner, some of you might be preparing drawings, but there is a square footage calculation that if you go over it, you need to have a license. So as you know, some projects expand. You know, you didn't think you were finishing out the basement, now you are. Otherwise, additions are coming on. We just wanted to affirmatively point out that you're not holding yourself out as a licensed architect. Now, if you are, that's something different, and feel free to represent it, but otherwise it's a clarification on that. Okay, payment, the payment terms have been softened a little bit in ways that we've introduced some blanks, some fill in the blanks, because not everybody charges interest. Not everybody has the same payment terms in terms of pay me in 7 days. Some want it 3 days, 5 days, 10 days, 14 days. So there's a little bit more flexibility in how the builder may want to structure the the payment. Invoicing according to the progress of the work. I've seen, if you're not using an HBA contract, I've seen it all across the board. I mean, invoicing just whenever kind of thing. So this is a little bit of communication about you can expect an invoice every 30 to 60 days. Obviously, if the project's financed, the lender is going to be controlling much of how the invoicing goes. You know, when the method by which it goes, sworn statements, lien waivers, everything along the lines. Again, fill in the blanks on late charges and interest, and then lien waivers upon request. So I just have to tell you, under Michigan law, if the owner asks for a lien waiver, you got to give it. But if the owner doesn't ask for a lien waiver, you don't necessarily have to give it. I mean, so I put that there upon request to try to ease some of your paperwork, but frankly, the law requires you to give a lien waiver when you've been asked to do so. Construction start. I gotta tell you, schedule is one of the big push areas because builders have been so flippin' busy. We've had some of our builders say, I want a $50,000 deposit to hold your spot. And some owners are willing to pay it. The problem happens when the builder actually does hold a spot in the schedule and the owner gets cold feet. They don't want to start, or they come up with some other excuse, they're not ready to go, financing hasn't come into place. But in any event, when it comes to construction start, we've softened the language to say the builder will endeavor to start within 30 days after the homeowner does all the things that we've identified in the contract. That language isn't new. After you have proof of financing and a whole bunch of other hoops the owner has to jump through. That helps you if you're getting nervous about your owner. And you may not want to start the project. Those other gatekeeping hoops that the owner has to jump through in the contract are still there. We've just softened the endeavor language. And then we simplified it to take out some of the archaic legalese in that paragraph. The estimated completion date. How many owners want to be in by Thanksgiving, by Christmas, by Easter? I mean, they all have benchmarks, or they want to be in their cottage before Memorial Day. So this is a really soft piece of the contract, and it's really helpful for the builder. I mean, your schedule is just a good faith estimate. It is not a guarantee. And so we simplified a little bit of the language, added some more reasons. The actual completion date could change. So we simplified that, but added a few more reasons why that completion date would change. And then what didn't change is the owner doesn't get any consequential damages, no additional loss or rent if they have to go rent someplace else while they're waiting for the home to be built. So this is really good language here to protect the builder, and it's very friendly to the builder. I'll go through these pretty quickly and then we'll open for questions. Allowances, very little change except that we added some language that you have a right to set off. So if there is a credit due to the owner, rather than an owner insisting that a check get cut, which we see owners doing that all the time, you can set that off against other overages. It's a legal concept and a legal term. We just built it back into the contract. Material price protection. Anybody had an issue with material pricing? So how many people do their contracts on a lump sum basis? Okay. How many on cost plus? Okay, well, cost plus, you've been able to dodge a few bullets. Lump sum has been very, very, very challenging when you can't control certain price, price changes. This is where the HBA contract can be very helpful because it does contain a material price escalation provision. It wasn't as helpful as we thought it could be, so we modified it to say, and leave a fill in the blank here, and this is really important on a lump sum contract. You can fill in the blank whatever you want. If the price of any material goes up by X percent, 2%, 3%, 5%, 10%, I think it might have said 20%, which is kind of crazy. So this is now a percent for you to determine what you want to set as a threshold before you're going to require the owner to pay that increase. And I have seen it as low as 2%. I've seen it most commonly 5%, but you're absorbing that cost. And it's possible you've already got that built in under a lump sum contract. You've already built that risk into your price, and this could be another layer of protection on it. So this was revised to be a little bit stronger to protect the builder, and frankly, to make it a one-way street. Before, it used to say that the price would be increased or decreased based on changes in the market. We've rewritten it so it's a one-way street. If there's an increase, the price goes up. So I don't mean this to sound this way, but I don't know that a lot of owners are gonna think to negotiate for the price decrease if there's a decrease in materials. I just don't think they think to negotiate it that way. In the commercial world they do, but just not, I don't see it in residential. Change orders. So change orders are kind of the bane of one's existence when you have a really good relationship with your customer, because you hate to keep shoving the paperwork in their face, but you need to, and you need to get them to sign off and to authorize changes. So the law in Michigan is that any change, this is under your occupational code, but it's also in the case law, is any change has to be in writing in order for you to enforce your lien. But something like an email or some confirmation from an owner, even if it's not signed, can be treated as that authorization to justify your change orders. So the change order debate is just huge. So we soften the language to say any authorization by the owner, and then later we've added some language about electronic transactions and then an email from the builder to the owner confirming a change would be sufficient to document a change order. So that if an owner refuses to sign a change order that you put in front of them, you might have a backstop with an email communication or a text that authorizes you to proceed with the work. And then the standard, I think this was standard, but maybe we changed it. Builder can require payment before proceeding with the changed work. Okay, foundation location assistance. When I met with the builder group, we talked about, do you help your customer pick out where the foundation is? Because we had some language in the contract that says the builder will help the owner, but the builder's not responsible. And the overwhelming opinion in the group is we don't want anything to do with it. So just take that out. We really don't want to have any role in placing where the home is gonna go. So that paragraph, paragraph 15 was removed and no longer appears in the contract. Insurance, builder's risk, just clarifying, somebody's got to have builder's risk. Who's procuring the builder's risk? Is it going to be the owner or the builder? Circle one in the contract. So that's meant to prompt you to make sure that nobody forgets to do that. Electronic dealings, this is new stuff, and this is really meant to kind of bring us up to where we are now in text messages and email messages, and just say, hey, that's an appropriate way for us to do business. But the backstory and the reason we want that is to make sure we can tie the owner into a change order through an owner email or a builder email. So just an agreement, you can send records electronically, you can do your transactions that way, and builder's email confirmation to the owner should be sufficient to deem that a change has been made. Okay, claim time limit. This was simplified just a little bit. This term in the contract basically says, hey, any claim you have against the builder has to be brought within X time period. I think it's 2 years. And that's it, any claim, no matter what the form is. We just simplified it a little bit, but we didn't really change it. But the reason I want to pause here is I think this is the best provision in the contract. It gives you a lot of leverage if you're negotiating with an owner on a mishap or something, and they get a hold of you 4 years later. This can be very useful. Your insurance companies like it because it does allow you to close the door on potential claims that creep up way down the road. So These are enforceable in Michigan. You see them all the time in home inspection agreements. Those are 6-month timeframes. Any claim after 6 months is barred, usually under home inspection agreement. So it's a key term, and I just want to pause and tell you that's one of the better provisions in the contract. Payment schedule. So mostly for newer builders, I think they might struggle sometimes on asking, or setting up how payments, how they want to get payments from the owner, especially if there's no lender involved. The payment schedule, as originally laid out in the HBA contract, had something like 5% up front, 5% at this point, then maybe 30% at framing, and we just took all those percentages out because, potentially you want a much larger percent at the front end, and maybe you want a large percent when you're getting your lumber or window package to make sure that you've got money in the door when that stuff is coming. So we just really have a framework of potential milestones, but leaving it up to the builder to modify it for what works best with the way they operate. Cost plus payment schedule. For those of you who are doing cost plus, we just modified the definition a little bit on what costs can be included in the cost plus model, adding workers' comp, just clarifying how you gross up or mark up your wages. But more importantly, we took out some not to exceed language and guaranteed maximum price language. I really don't know why that was in there, but it shouldn't have been, and we removed it. Outside work. This was a product of the roundtable with the builders who said, hey, when we've got owners who are taking over some of the work, our subcontractors, our trade partners, they're not real happy because their pricing was based upon maybe a larger scope of work. So adding some language that gives some flexibility to the builder to reprice certain work if the owner's taking some scope back in, because when the owner does that, they could be denying you and or your trade partner some profit. So, all right, that's it. No real bombshells here. It's just really repackaging and refreshing some of the language that's there.